What waterfront owners really own in Michigan. Why Great Lakes shoreline rights, inland lake rights, public access, and private ownership are not the same thing. A person walking the beach. A waterfront owner defending privacy. A public shoreline few people fully understand. That is usually where waterfront disputes begin. Most people assume waterfront ownership is simple. You own the shoreline. Everyone else stays off it. In Michigan, it is often more complicated than that. This matters when buyers compare properties. Two waterfront homes may look similar on Zillow. One may sit on Lake Michigan, the other may sit on an inland lake. Practical privacy is not the same as legal exclusivity. And many waterfront disputes begin when people confuse those two different ideas. The distinction between the two often shapes the ownership experience more than buyers realize. This video is not about taking sides in shoreline disputes. It's about helping buyers understand why waterfront ownership can feel very different from one property to the next. The core issue is not usually what is right or wrong in a shoreline argument. The core issue is that people often confuse four separate categories: ownership rights, access rights, public trust rights, and shoreline use rights. Why waterfront ownership is more complicated than most buyers think. When a waterfront buyer says, "I want waterfront," what they usually mean is a combination of views, access, privacy, shoreline use, and control. The problem is that most of those are not the same right. Waterfront ownership is better understood as a bundle of rights, and the contents of that bundle vary depending on the body of water involved and the legal history of the shoreline. Michigan law draws important distinctions between Great Lake shorelines and inland lakes. It also distinguishes between a property that directly touches the water and one that is separated from the water by a public road, a platted walk, a boulevard, or a public access strip. Even where a property owner holds riparian or littoral rights, those rights may coexist with public trust rights, public navigation rights, or dedications that allow public ingress and egress. That is why so many waterfront disputes are really expectation disputes. The parties are often arguing from different assumptions about what the owner actually owns and what the public is actually allowed to do. For buyers, this is not academic. If you think you are buying exclusive shoreline control and later learn that the public may lawfully walk below the ordinary high water mark or may legally enter the water from an adjacent public road end, your ownership experience changes. If you assume an inland lake frontage works like the Great Lakes beachfront, that can be wrong in the other direction. If you assume a public access next door is just a path, but it operates as a real water access point in summer, that can affect noise, parking, and privacy expectations in ways the listing sheet never explained. That is why the most important waterfront question is not how many feet of shoreline the property has. The more important question is what rights come with that shoreline and what rights remain with the public or adjacent property owners. So you really want to understand what is in your bundle of rights when you're looking at buying waterfront property in Michigan. Why Great Lakes waterfront is different. Michigan treats the Great Lakes differently from inland lakes. Michigan Eagle explains that distinction in this way. The state of Michigan holds the Great Lakes coastline in a public trust, owns the submerged lands underneath the Great Lakes, and private shoreline property generally extends to the water's edge as a movable freehold. A movable freehold. Because the line changes with lake levels. So that's when you've probably heard the ordinary high water mark. Well, that changes from year to year, from week to week even, from day to day. What the ordinary high water mark is a key term in understanding what your bundle of rights is. That's the measuring stick, so to speak, the ordinary high water mark. Eagle also states that the public trust doctrine provides the public with the right to walk along the shoreline below the ordinary high water mark. The source for that is Michigan Eagle, Great Lakes Public Trust, and Ordinary High Water Mark. That combination is what makes Great Lakes ownership feel counterintuitive to many buyers. A private owner may hold title to a shoreline parcel and still not have the kind of exclusive control that many people assume and that comes with inland lake frontage. Below the ordinary high water mark, the state holds the Great Lakes bottomlands in trust for public use and enjoyment and significant occupation, or use of the bottomlands can require state permits or even conveyances. A private owner may hold title to a shoreline parcel and still not have the kind of exclusive control that many people assume comes with inland waterfront. Below the ordinary high water mark, the state holds Great Lakes bottomlands in trust for public use and enjoyment, and significant occupation or use of the bottomlands can require state permits or even conveyances. Eagle says a conveyance is required for the occupation and use of state-owned public trust bottomlands in the Great Lakes, and permits are required for filling, dredging, installation of seawalls, docks, lifts, and similar structures below the statutory ordinary high water mark. This is where buyers get tripped up by the phrase ordinary high water mark. In Michigan, Eagle uses an elevation-based ordinary high water mark for Great Lakes permitting under Part 325. And for Lakes Michigan and Huron, the statutory elevation is 579.8 feet above sea level under the 1955 datum. Eagle also notes that people will hear about a natural ordinary high water mark, which is the point where the water's long-term presence leaves a distinct physical mark in the soil or in the surface configuration or vegetation, and that the statutory and natural marks are not always in the same place. Source for that is Michigan Eagle Ordinary High Water Mark Guidance and MCL 324.32502. For real-world ownership, that means the Great Lakes shoreline is dynamic, both physically and legally. This can affect privacy expectations, shoreline improvements, future use, and ultimately property value. Erosion, accretion, water level shifts, bluff movement, beach width, permit requirements, and public trust use all shape ownership experience over time. A buyer is not simply buying a static line on a plat map. They are buying into a changing shoreline environment subject to public trust doctrine and state shoreline regulation. The Beach Walker case and the ordinary high water mark. Michigan's landmark case is Glass versus Gokul, Don't know if I'm pronouncing that correctly or not, but in that case, Michigan Supreme Court addressed the following: whether a member of the public could walk along the Great Lakes shoreline where the private owner claimed title to the water's edge. The court held that Michigan's public trust doctrine protects public walking along the Great Lakes shoreline up to and including land below the ordinary high water mark because pedestrian travel is inherent in the traditionally protected public rights of fishing, hunting, and navigation. The source for that is Glass versus Gokul, Michigan Supreme Court, 2005. The court described the ordinary high water mark using language it drew from Wisconsin. It is the point where the presence and action of the water are so continuous that they leave a distinct mark through erosion or the destruction of terrestrial vegetation or another easily recognizable characteristic. The court also made it clear that Great Lakes waterfront is held subject to the public trust, even where a private owner otherwise holds littoral title. That holding, or that judgment made by the Michigan Supreme Court, is the reason why Michigan is not like Wisconsin on this issue. The recent Shorewood dispute in Wisconsin exists partly because Wisconsin law has not resolved Great Lakes beach walking in the same way that Michigan did in the Glass case, or what is commonly called now the beach walker case in Michigan. The Glass case, or the beach walker case, is the starting point for understanding that on the Great Lakes, private ownership and public shoreline use can coexist. But buyers should not overread Glass, by the way. The case supports walking below the ordinary high water mark on the Great Lakes. It does not mean that the public may treat all private shoreline as a public beach, and it does not answer every shoreline use question. Even in Michigan road end cases, courts have distinguished between entering and leaving the water versus lounging, picnicking, installing docks, or permanently mooring boats. That distinction is practical as much as legal. Beach walking, public ingress and egress, and day-long occupation of shoreline are not automatically the same thing. When buyers fail to separate those ideas, they often misjudge the privacy and use profile of a Great Lakes waterfront parcel. Why inland lakes are totally different. This is where many waterfront buyers make the biggest conceptual mistake. They take a Great Lakes rule and assume it applies to inland lakes. Or they buy an inland lake parcel assuming it carries a Great Lakes-style public shoreline corridor. Michigan generally does not treat inland lake frontage that way. Michigan's own inland lake guidance says that unlike the Great Lakes, the bottomlands of natural inland lakes and streams are owned by riparian or littoral property owners. The same guide explains that owners with property contiguous to an inland lake or stream hold riparian rights that include access to navigable waters, dockage, general water use, and title to natural accretions. At the same time, the state still protects the public trust in the water itself, and the water, fish, and wildlife remain public resources managed by the state. That is a very important ownership pattern. On most inland lakes, the shoreline owner's rights are stronger with respect to the bottomlands adjacent to the parcel. Michigan courts have likewise recognized that riparian owners of inland lakes generally own the bottomlands from the shore toward the middle of the lake in sort of like a pie-like fashion, while the public's navigation rights include temporary anchoring, but not the full suite of exclusive riparian rights such as permanent docking or permanent anchorage. So the takeaway is not that inland lakes are more private in every sense. Instead, the legal takeaway is that the legal architecture is different. On inland lakes, the public may use public waters for navigation, fishing, and similar activities, but buyers should not assume a Great Lakes-style right to walk privately owned inland shoreline or bottomlands without permission. Michigan lake law materials commonly make exactly that distinction. That difference alone can materially change privacy expectations, dock rights, bottomland disputes, and value. A buyer who wants strong control over the immediate shoreline experience may prefer one type of water body, whereas a buyer who wants long beach walking expectations may prefer another. The mistake is assuming that all waterfront behaves the same. Source: Michigan Eagle Inland Lakes and Streams Guidance. Public access versus shoreline access. A second major source of confusion is the difference between public access and public shoreline use. Michigan courts have repeatedly treated those as separate questions. In McCardle versus Smolin, the Michigan Supreme Court said that whether the public may enter and leave the water from a boulevard and whether the public may lounge or picnic there depends on the scope of the dedication. In other words, ownership of riparian rights does not automatically answer the public use question, and public access does not automatically create a public beach. Michigan road end cases reinforce that point. In Thies versus Howland, the Supreme Court explained that public ways ending at navigable waters are generally deemed to provide public access to the water, and that wharfs or docks at such a place can be built to aid public access. But the same case drew important limits around the rights of non-riparian users and backlot owners, especially when the claimed rights exceeded the scope of the dedication or the easement. MSU Extension summarizes the practical distinction well. It explains that the public road ends at inland lakes or streams generally provide the public with access to the water, while roads running parallel to the water in platted subdivisions are a different matter and often leave riparian rights with the front lot owners. The same MSU analysis points to Michigan's public road end statute, MCL 324.30111B, which defines a public road end and restricts uses such as hoists, overnight mooring, obstruction of ingress and egress, and docks beyond a single seasonal public dock authorized by the local government. That is why buyers should ask not only, is there public access nearby, but also, what kind of access is it? A state park beach is different from a public road end. A parallel platted boulevard is different from a perpendicular street ending at the water. A Great Lakes shoreline corridor below the ordinary high water mark is different from a dedicated strip allowing ingress and egress. Those differences are not cosmetic. They define how the shoreline actually functions. Source: MSU Extension Summary of Michigan Public Road End and MCL 324.30111B. Local lessons from Empire, Northport, and Cathead Bay in Leelanau County. Leelanau County is a great place to learn these distinctions because it compresses so many shoreline types into one small geography. Within a short drive, you can move from classic Great Lakes frontage to public road end access to state park shoreline to inland and inland-like waters and still remain physically tied to the Great Lakes landscape. South Bar Lake in Empire. South Bar Lake is a good reminder that water body labels can oversimplify. The National Park Service materials explain that South Bar Lake, just north of Empire, was once part of Lake Michigan and was separated when longshore currents deposited the sandbar that now divides the two. A local water quality report describes the lake as a former embayment of Lake Michigan and notes that its outlet flow to Lake Michigan is variable depending on sand deposition and lake levels. The Village of Empire's Lake Michigan Beach Park also sits alongside the shores of both Lake Michigan and South Bar Lake. So why does this matter for buyers? Because a place like South Bar Lake can feel inland in one sense and Great Lakes adjacent in another. It is a separate body of water. It has its own public access patterns. It is physically tied to Lake Michigan's shoreline system. And it sits in a recreational setting where public use patterns are shaped not just by private parcels, but by nearby public land and beaches. All of that does not produce a simple one-line answer about rights. Instead, it produces a due diligence question. What exactly is the ownership and access framework here, and how does the connection to the surrounding shoreline system affect actual use? Buyers often assume a water body is either Great Lakes waterfront or inland lake waterfront. South Bar Lake demonstrates that reality can be more nuanced. Sources for this: National Park Service and South Bar Lake water quality materials. All right, let's move on to Northport's 7th Street access. Northport, my hometown, had a 7th Street access controversy, and it teaches a different lesson. A long-running federal case described the 7th Street right-of-way as public access to Grand Traverse Bay, actually Northport Bay, which sits within Grand Traverse Bay, of Lake Michigan, and noted that adjacent property owners objected to public use and sought to stop the area from being used as a public beach. More recently, Interlochen Public Radio reported that residents had used the 7th Street Road End Beach in Northport for swimming for more than 50 years, and I can attest to that. I preferred the 5th Street access to 7th Street, but I also use 7th Street. And that a July 2021 confrontation between beach owners and neighbors became a flashpoint in the local debate over road end use. The legal and practical lesson is the same one Michigan courts have been repeating for years. Public access is not the same thing as unrestricted public beach use. IPR summarized the local argument this way. On the Great Lakes, people can generally be below the high water mark, but road end rules are narrower and often focus on entering and leaving, ingress and egress of the water rather than long-term occupation of the access parcel itself. So go back to our previous discussion about walking along the shoreline or going in and out versus sort of relaxing, picnicking, sunbathing at that public road end access. The type of use on the waterfront is the question, okay? Northport's Village Council voted to remove language from street end signs stating that the site was, quote, not a public beach or picnic area, which shows how contested the messaging and expectations had become. So the point here for buyers is not to take sides in these disputes. The point is to understand that a nearby access can be legally real, socially contested, and operationally significant all at once. That can affect traffic, parking, noise, your relationship with your neighbors, and the overall lived experience of owning nearby waterfront or near water property. In other words, these questions are going to affect your lifestyle. Sources are here are Interlochen Public Radio reporting and the Village of Northport public meeting records. Next, let's talk about Cathead Bay and why Cathead Bay feels different. Cathead Bay shows the opposite dynamic. Legally, it is still Great Lakes shoreline, but experientially, it feels very different from Village Road End Beach or developed shoreline neighborhoods. The DNR describes Cathead Bay as a large natural area within Leelanau State Park with a narrow sand and rock beach, low dune ridges, interdunal wetlands, forested dunes, and state endangered piping plovers. Some shoreline areas may be seasonally closed because of nesting habitat. The state park page and map show that access is trail-based through parkland with shoreline access reached from the Cathead Bay Trail system. This is exactly why two Great Lakes properties operating under the same broad public trust framework may still feel completely different. One stretch of shoreline can function like a lightly programmed natural coast with habitat protections, trail access, and ecological sensitivity. Another can function like a village-adjacent swim access with neighborhood friction over parking and beach behavior. The law matters, but so do topography, public land ownership, habitat restrictions, trail design, and how people actually reach the water. Source here is Michigan DNR Cathead Bay Natural Area Materials. Legally, Cathead Bay still operates within the same broad Great Lakes framework, but ownership experience is not determined by legal rights alone. Practical access matters. In places such as Cathead Bay in Leelanau County, natural barriers, trail-based access, and surrounding public land can influence the ownership experience just as much as the underlying legal framework. A shoreline that requires trails, park access, habitat protections, and a longer walk may feel far more private than a shoreline with a convenient road end access and regular public use. And that's something that I think is very unique about all of the waterfront property along Cathead Bay, is that it can only be accessed by a private drive, and it is surrounded by Leelanau State Park and the Leelanau Conservancy land. So it's surrounded by protected land, and it can only really be practically accessed on a private drive. Now, theoretically, someone could walk all the way from Leelanau State Park that begins near Woolsey Airport and make their way along the shoreline, walking along the high water mark for miles to get to Cathead Bay. Or they could get a machete and try to fight their way through the really thick vegetation on the northern end near to the lighthouse and make their way to the duney area that surrounds Cathead Bay. But practically, what the topography and how the land is situated and the dense vegetation, it really creates a private and kind of secluded area for those waterfront property owners along Cathead Bay. So you can see that legal rights and practical access are not always the same thing. Many buyers focus on what the law allows, but ownership experience is often shaped by how people actually reach and use the shoreline. Waterfront buyer due diligence and what waterfront owners actually own. So what does a waterfront owner actually own in Michigan? Usually the owner owns the upland parcel and whatever riparian or littoral rights attached to it. On the Great Lakes, that ownership is shaped by a movable shoreline boundary and by public trust rights below the ordinary high water mark. On natural inland lakes, on the other hand, the owner generally has stronger bottomland rights adjacent to the parcel. but those rights still coexist with public interests in navigation, fishing, and environmental regulation. At properties near public road ends, platted walks, or shoreline parks, use expectations can be further shaped by dedicated language, statutory limits, and neighboring public access patterns. That is why my due diligence questions for waterfront buyers are usually more important than the marketing description they read in the listing. Before assigning value to shoreline frontage, buyers should ask the following. What kind of water body is this? Is it the Great Lakes? Is it a bay within the Great Lakes? Is it an inland lake or stream, or a connected water body with hybrid practical issues such as the example about South Bar? Does the parcel directly touch the water, or is it separated by a road or walkway, parkland, or dedicated access strip? If this is Great Lakes frontage, where is the ordinary high water mark likely to matter for use, walking rights, and permitting? If this is inland frontage, what bottomland and dockage rights are actually attached to the parcel, and are there any easements benefiting others? Is there a public road end, beach park, trail access, or shoreline corridor nearby that could materially affect privacy or traffic? Are there eagle or local permitting constraints for seawalls, stairs, dunes, docks, dredging, fill, or shoreline protection? Are there habitat, erosion, bluff, or other physical conditions that change how the shoreline can actually be used? This is an educational overview, not legal advice. I am not an attorney, although I did stay at a Holiday Inn last night. But Michigan waterfront is highly fact-specific, and the answer can turn on deeds, plats, easements, dedicated language, court history, permit status, and the exact water body involved. Buyers should consult qualified legal counsel, title professionals, and the appropriate township, village, county, and state agencies before relying on assumptions about shoreline rights. Most buyers begin by asking, how much shoreline does this property have? How many front feet comes with this property? How much frontage on Lake Michigan or on the waterfront is there? But a better question isn't about the number of front feet or how much frontage. It is, what rights come with that shoreline? Because waterfront ownership is not a single right. It is a bundle of rights, and two waterfront properties with similar frontage, similar views, and similar prices may provide very different ownership experiences depending on those rights. That is why understanding waterfront ownership is not just a title question. It is an ownership experience question. The most successful waterfront buyers are not the ones who memorize shoreline law. They are the ones who understand shoreline rights translate into real-world ownership experience. Because in Michigan, the most important question is rarely how much shoreline a property has, how many front feet it has. The much more important question is what comes with that frontage.